All rise. The President and judges of the Caribbean Court of Justice.
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados. Hearing of appeal in CCJ Civil Appeal BBCV number 2 of 2019 between Prince Sinckler and Editha Sinckler. This appeal is being heard by their honors, Mr. Justice Saunders, President, Mr. Justice Witt, Madam Justice Rajnatley, Mr. Justice Barrow, and Mr. Justice Jamadar. Please state your appearances for the court.
Dayton Rollins for the appellant.
And Dennis Headley, in association with my learned friend Mr. Dave Cumberbatch and Mr. Derek Boyce, who unfortunately can't be here today.
Yes.
For the respondent.
Yes. Good afternoon, Counsel. Mr. Rollins, are you ready to make your submissions?
I did. Wait.
Yes, please proceed.
My submissions, my lord, were filed
Is there anything you want to add to those written submissions, Mr. Rollins?
No, my lord.
So you stand on those submissions?
I do, my lord.
Okay. And there isn't anything that you wish to particularly emphasize to us?
There is, my lord. In my address, I will do that. Please, my lord, Mr. Motley, who is leading me in this matter, was out of the jurisdiction, and the court had asked him to submit his submissions in writing. I'm unaware as to whether or not he did that.
No, we didn't get those.
No, we didn't.
No.
It falls upon me then, my lord, to address the court and to elaborate on my submission.
Yes, please go ahead.
My lord, I'm obliged to indicate to the court that I labored under the impression that the hearing before Madam Justice Kentish on the 8th of November 2007, that the appellant was not present. I only found out that the appellant was indeed present at that hearing when I read Mr. Headley's skeleton arguments, in which he indicated that the appellant was indeed present. I then confirmed the presence of the appellant with my son, Kwame Rollins, who held papers for me on that day and had been instructed to ask for an adjournment. I apologize for that error, my lords. And it appears, my lords, that the Court of Appeal, on the hearing of the appeal on the 14th of December 2007, was of the same view as the order reads in the end, referring the matter back to the High Court. The order reads, in the presence of the appellant husband, the court appeared to have been of the view that the appellant was not present. I don't think, I apologize for that error, my lord, but I do not think that that has any material bearing on the matter before us, before the court. My lord, I am persuaded to take the court back to the hearing before Madam Kentish on the 8th of November 2007 and what transpired that day. Number one, my lord, the court refused the application for a short adjournment. Number two, the court failed to make any inquiry as to the means of the pardon. Number three, the court was not mindful of the fact that there was an order for maintenance by the appellant in the sum of $600 monthly in respect of the child of the marriage who was attending the University of the West Indies. Number four, the court proceeded with the hearing of the matter in my absence. Number five, the court failed to take account of the provisions of Section 71 of the Family Law Act. And there, my lords, by just making an order out of the blue, no consideration was given by the court to the provisions which are specifically applicable to spousal maintenance.
Counsel, help me, please.
And I have attempted to set that out.
Counsel, could you give me some assistance?
In my written
Counsel,
submission,
Counsel,
number
I'd like
8,
to ask you a
yes.
question, some help from you. Would like to ask you for some help. Yeah?
Yes, my lord.
Yes. The order that you are complaining about went on appeal to the Court of Appeal. Is that correct?
It did. It did.
Well, then can you now impugn the order, it having been upheld on appeal, and that appeal is finished?
I'm giving the history of the whole case, my lord.
Yes.
And
but
I'm just mentioning the history of the whole case, which has led us to this.
No, but you see, what we don't want is for you to believe that if there was anything that you say the trial judge did wrongly, that somehow that error or those errors will influence any decision of ours. All of those supposed errors are res judicata. They are not to be factored in what we do now. So it might be part of the history, but it is a part of the history which is not really of any relevance now.
The problem
With the
is,
greatest respect,
the problem is,
greatest respect,
Mr. Rollins, the problem is that there's only one ground of appeal, as far as I see. And that is that the 12-month rule of practice, whatever that is, was not applied and should have been applied. So that is what we are dealing with, nothing else.
I take the view, my lord, and I have always taken the view from the day this order was imposed upon the appellant, that the circumstances that existed in the court on that day that the imposition of this maintenance order upon a man who was separated from his wife for 14 years and appears in a court of law where an application has been made for maintenance without any consideration, I consider it to be a grave imposition of injustice upon my client. And that is what has led to this hearing today. And I cannot resist, my lords, with the greatest respect, I cannot resist emphasizing that from the beginning, this order ought never to have been made. I appreciate, my lord, your sub judice ruling, but that has led us to where we are today. Very well, my lord.
Perhaps you could assist us,
If I
Mr.
am-
Rawlins, by taking us to the point of your appeal, which is the alleged 12 months rule of practice. Perhaps if you moved on to that, that would give us some assistance.
As my lady pleases. In my submission, my lord, I have indicated that both the practice in England as well as Australia, England before we adopted the Family Law Act of Australia, the practice of the 12-month rule applied in England. When we adopted the Family Law Act of Australia, the enforcement of an order for maintenance in both countries by reason of the authorities which have been submitted was confined was limited to 12 months. If within 12 months no maintenance was paid, then the court was loath to order the arrears to be paid. I have submitted those cases, both the ones that obtained in England and in Australia. There is one case that helps us in this matter, which was decided by the Barbadian court. And that is contained, my lady, in page 12 of my written submission. It indicates, my lord, that the courts in Barbados, in their adjudication, did not apply the 12-month rule, but indicated that maintenance only maintenance will be enforced within a reasonable time.
Just as a matter of interest, Mr. Rawlins, you refer to the 12-month rule. When, in your view, did the 12 months begin to run? From what date?
From the date that the Court of Appeal made the order an interim order. Look, after the Court of Appeal made the appeal, let me indicate when it did. On the 14th of December 2007, my lord, it was made an interim order. As will be seen, my lord, in paragraph 5 of my submission, some 5 years after, on the 27th of November 2012, an application was made by the respondent for the enforcement by imprisonment of the order made the 8th of November 2007, some 5 years after. And that is the crux of the matter in this case, where if you succinctly regard the appeal as being won on that point only. So that this court is asked to determine whether or not the...
But just a minute, the order for imprisonment was an order made in a proceeding that commenced when?
The submission by your colleague, Mr. Rawlins, is that it was on the 30th of September 2008 that the wife made an application seeking to enforce the maintenance order of 8 November 2007. So
I am not aware of any such
they
application.
say 30 September 08, wife filed an application seeking to enforce the maintenance order.
I am not aware of any such act.
Mr. Rawlins, the Court of Appeal, in their judgment at paragraph 8, they refer to that. They take that as a given. They say thereafter the respondent sought to enforce the maintenance order by filing an application supported by affidavit on the 30th of September 2008. Do you have the Court of Appeal judgment there, Mr. Rawlins, on paragraph 8? 8, 9, and 10, I think, would be helpful.
You have a copy of that order?
It's a judgment of the Court of Appeal, Mr. Rawlins.
We're looking at the judgment of the Court of Appeal.
The last judgment.
The one you appealed.
Well, Mr. Rawlins, when was the application for maintenance made? When was the application made?
The application was made, I think, on the 29th of April 2008. No, the application. I have an application 15th of November 2010, supported by an affidavit.
For what?
For maintenance.
But how could that be if you filed an appeal on the 14th of December 2007?
Well, this is for enforcement, my lord. 15th of November 2010. For enforcement. That is the first application with which I had to deal with.
Mr. Rollins, my sister drew your attention to the decision of the Court of Appeal, which was given on May 12th, 2016. Do you have that decision in your papers?
I have that decision, my lord, and I have been helped by Mr. Headley, and it is referred to in Affidavit 30. That is not correct, my lord. I never was involved in any application for the enforcement of the order made on the 8th of November 2007. I was never involved. The first time I was involved is in the application which was made on the 15th of November 2010.
Yes, Mr. Rollins, but you, because of your non-involvement, you cannot get around the fact that in proceedings in which you were counsel before the Court of Appeal, the Court of Appeal stated in its judgment that, as my sister has mentioned to you, that there was this application dated.
And suppose there wasn't, suppose they're wrong, my lord, suppose there was no such application on the 30th of September 2008. Suppose there were not, it is just thereafter dishonest court enforcement maintenance order affidavit on the 30th. I have no such application. I have no such affidavit. I have the one of the 24th of June. I do not, I wasn't aware of this.
Well,
so they must have made a mistake there.
Well, Mr. Rollins.
I have no such application.
Mr. Rollins, do you understand what you are saying? You are telling us.
I do clearly.
You are saying, disregard what is stated in the solemn judgment of these three judges and to believe what your recollection tells you or does not tell you took place.
And if it was wrong what they said, couldn't we not have expected you to say so in the notice of appeal, so that we would have a dispute on that, but it was not said. So we have to assume that this is so.
I could only ask, Lord, that I be shown the application, because I have application made on the 30th of September 2008, and that the court, not only I, but that the court be shown that application.
No, Mr.
Just
Rollins.
because it is.
Mr. Rollins, it does not go so, it cannot go so. It is, as my brother Witter said to you, this is a solemn judgment of the Court of Appeal. If there was an error, if there was a misstatement of such a material fact, you should have appealed against that false statement of fact. Part of the problem may be, Mr. Rollins, and I'm only raising it with you as a possibility, that again, if you look at your colleague's submission, the statement is made that when that hearing was conducted, neither you nor your client was present. So it may well be that you have no recollection of it because you were not present. Now, why you were not present, why your client was not present, is not a matter for us. But what we have clear is there is this finding of fact by the Court of Appeal that there was this hearing, there was this application.
Whether or not there was an application made by the respondent on the 30th of September 2008, it was not, no order was made in respect of any. Indeed, two applications were made by the respondent, one of which was withdrawn. And I was not privy to these applications. But what I would say is, even if an application was made on the 30th of September 2008, the actual order for commitment was made some 5 years after.
Whose fault is that? If the court system took that long to process an application, is that the fault of the respondent? The respondent was trying as diligently as she could to prosecute the enforcement of the maintenance order. In June 2008, you agree that, no, wait a minute. On the 8th of November, the Court of Appeal varied it to an interim order. Agreed?
Agreed.
Right. Thereafter, the record shows that the respondent tried first on the 8th of November 2007, and then again on the 15th of November 2010 to enforce. So that what that demonstrates, does it not, is that the respondent was trying at least since the 8th of November, the 30th of September 2008 to enforce the arrears. Is that not what that shows?
Within the prescribed time.
The point is, we cannot ascribe fault to the respondent if the system did not determine her application to enforce arrears years later. Can we?
Yes, my lord. In the circumstances here, it is the responsibility of the lawyer for his client to see that the procedure is complied with and pursued. You can't make an order and just because so-called system, and I don't know of any application for any fault or blame can be placed on any system. If an order is made for maintenance and an order is made for imprisonment, 5 years thereafter, 5 or 6 years thereafter, that is the issue in my submission before this court. Yes, she might have made an application, but not pursue it.
Mr. Rawlins, what are you concerned with here? The appeal, the ground of appeal that you have rested your case on is about delay. What I am particularly interested in is when you say that delay began and what is the date when the delay ended.
Delay began in my submission, my lord, on the 15th of December 2007. The delay ended when the order for a custodial, when a custodial order was made, which is some years after.
But the custodial order would have been made at the end of a proceeding. When did that proceeding in which the custodial order was made commence?
On the 27th of November, an application was made 5 years after.
Is this the application of the 15th of November 2010 that you were telling us about earlier, the one that you seem to have found in your papers?
The one that I seen in 2010.
2010, yes. 15th of November 2010. Is that the date you've given us?
That is the application I have.
Okay.
No order was made on that.
So between 2007 and 15th of November 2010, no application was made by the respondent?
No, my lord. Not with which I was involved.
It doesn't matter if you were involved, that's exactly the point. What matters is
Not
that...
not that I am aware of. Lord.
Well, exactly the point, Mr. Rawlins. And if you are unaware of something which factually occurred, which occurred with full formality in the system, then it does not matter that you are not aware for whatever reason. It occurred.
Yes, my lord. But if an order was made on the 14th of December 2007, and an application was made November the 15th, 2010, that's nearly 3 years after.
But that is not
the
when,
application
that
was-
is, with respect, that is not when the application was made. The application was made on 30th of September 2008.
But I have the application before me, my lord.
You have
Affidavit
Mr. Rawlins, you have an application before you. What you do not have is the application of 30 September 2008.
Mr. Rollins, maybe, can we just go through the chronology and maybe this will help the situation. The maintenance order was first granted on the 8th of November 2007. You agree with that?
Yes,
All right. You appealed that decision in December 2007. Agreed?
agreed, my lord.
All right. So there's an appeal. That appeal, an order was made on that appeal on the 8th of November.
No,
Sorry.
14th.
On the 14th of December. No, when was the appeal? It was converted into an interim order. Yes? And referred to
Yes,
the
sir.
High Court for the maintenance application to be heard. Correct?
Yes, yes, sir.
Right. Then that application was duly heard, and on the 6th of June 2008, it was discharged by Justice Richards. Yes?
Yes, my lord.
All right. So from getting the order in November 2007 until it was discharged in June 2008, there was litigation in the courts about this order. There was an appeal. The appeal deemed it an interim order and sent it back for rehearing. Correct? That application was heard.
Yes,
and in,
yes, the
and
appeal
in
was
Ju- and in June
on the 14th of,
and in June 2008, the interim order was discharged. Agreed?
yes, sir.
All right. So in June 2008, the litigation about this interim order came to an end. Except for the arrears. About the substance of the order. Yes? Don't you agree with that, Mr.? Don't you agree?
Yes, I agree that
All right.
that the order was discharged.
Right.
Was discharged by Judge Richards.
Good, good. So, on the record shows that on the 30th of September 2008, 3 months after the discharge, the respondent came to enforce the arrears that were never paid while all this litigation was going on. You never got served with that. Because
No,
you were
sir.
not, fair enough, because you were not served, Richards J., the same judge, directed that the documents be refiled and served on you again. And
No,
and
sir.
that's what the
No,
record
sir.
shows.
Judge Richards,
Hence,
I cannot agree, my lord.
that's not what the record
Judge Richards
shows.
made no. The Judge Richards in this matter only discharged the order and then proceeded to hear the application. No application was made to Judge Richards for enforcement. The only applications that that were made for enforcement of the order, and there were 2 applications made, was before Judge Kentish.
All right. But the only one you are aware of is the 15th of November, 2010.
That is the one I have.
Okay.
The only one I have.
All right.
And it is the only one to enforce it, sir.
You see, Mr. Rollins, your complaint is that too much time was taken to make this application for maintenance. That's your complaint, is that? Is it correct?
For
That-
enforcement.
To enforce
That
it.
is,
To enforce it,
that is,
right.
that is.
And I've been trying to get from you the extent of the delay. That is, the time from which you start counting and the time at which you say the respondent began a process which was in excess of the period that was reasonable. And so far, what I'm understanding from you is that you start counting at the, is it that the 30th of the 14th of December? There was in June the litigation about the interim order. That's June 2008. That litigation ended. And she attempted to enforce the arrears from September 2008. Is that correct?
Not in my view, but I'm not aware of an application which I have before me recites the appellate, the appeal, recites the order, recites the discharge and everything, and the application is dated the 15th of November 2010.
What do you have before you, Mr.?
What document is that you're reading from?
The respondent,
Does
Filed on
it, is that a
15th
document that was
November.
filed with the court?
yes, sir.
Does it have a page
an app-
number on it?
Ask him again.
Does it have a page number on it? A page number from this court at the bottom, like page 35 of 216 or anything
No,
else?
it does not. My lord. It is referred to. I believe it is referred to in Mr. Headley's skeleton argument.
And what is the nature of the document? What document is it?
It's an application for enforcement backed by an affidavit.
That's correct. That's correct. We filed application. One before. That reply doesn't consider the she said, no, you have to do it.
Okay, this is the appeals judgment.
Yeah.
Okay. I think we are a little closer to understanding the situation. The respondent filed an application on the 30th of September 2008. And that application came up for hearing on the 24th of June 2010 before Justice Richards. You were not present, and your client was
Justice
not present.
Richard Millard,
I beg your pardon?
not Justice Richard Millard. Justice Richard only came into the case subsequent to the order of the Court of Appeal, making the order an interim order and referring it to
Mr. Rawlins,
discharge of the.
Mr. Rawlins, do you have you are appealing the Court of Appeal's judgment, is that correct?
I am.
The judgment that you are appealing, do you have it?
I have it.
I want you to look at paragraph 8 of that judgment.
I have.
You see paragraph 8?
Yes.
It says that the lady filed an application on the 30th of September 2008. And that
Can't be right. The application.
No, I'm
was filed
just telling you
on-
what it says. I'm not asking you what you think is right or wrong. The judgment that you are appealing, and you never appealed against the accuracy of what I am reading out here. So we have to take it as being correct. And what it says is that the lady filed an application on the 30th of September 2008. And that application came before Justice Richards on the 24th of June 2010. But you were not there, which is why you probably have no recollection of it. And your client was not there either. And so Justice Richards issued a summons with a warning to your client, and she directed that the documents that had been filed on the 30th of September 2008 be refiled. On the 15th of November 2010, the respondent filed an application with the supporting affidavit as directed by the court. So that I grant you this. On the 30th of September, she filed. On the 24th of June 2010, the court said, no, we would like you to refile these documents. So that there was a delay from the 24th of June 2010 to the 15th of November 2010. So that is the delay that you're talking about. You are probably saying she should have filed on the 25th of June. But she took, what's it, 3 or 4 months? 5 months before she filed. Now the question is whether this 12-month rule is even applicable, even accepting that there was a 12-month rule. 12 months have not yet elapsed.
May I respectfully draw the court to the attention of paragraph 9. On the 7th of September 2011, the respondent withdrew the 2008 application, as there were by that time 2 applications before the court for the same relief. So that if that is withdrawn, the application to which I refer, which was filed on the 15th of November 2010, is the application which I am aware and attended the hearing for in respect of this matter.
Yes,
the
but
2008
I understand what
withdrawn.
you're saying, Mr. Rawlins, but it is equally the case that there had been a previous application filed, which application, for whatever reason, we don't have any information as to whether it was or was not served, but when it came on for hearing, neither you nor the client was present. And so the judge said to refile it. And it was refiled. It was refiled on the 15th of November. So when you start counting dates, it would be entirely unfair to the respondent to take the view that you must start counting time from the 15th of November, because she had previously filed the application on the 30th of September. And it was that application remained in the system until the 24th of June
2010.
2010. So all of that time cannot be attributed to delay on the part of the respondent, because that application had been filed and was in the court system.
My position is that I am ignorant to the existence of that application.
We understand that.
And I do not, with the greatest respect, say in a court, in the absence of counsel and his client, making an order for an application with which the respondent is not represented in any matter for refiling of an application. I can only say to this court, in sincerity, that I am not aware of any application being made within the 12-month period.
Mr. Rawlins, as my brother Barrow has been at pains to try to point out to you, the fact that you are unaware of it doesn't make it any less of a fact. It either was filed or it was not. Whether you were aware or not does not alter the fact that it was filed. We have a Court of Appeal judgment from which you are appealing. And guess what? You have not said to us that what the Court of Appeal said there in paragraph 8 is inaccurate. It's a figment of their imagination. It never happened. It is wrong. You must not have regard to it. You have not said that to us in your notice of appeal.
I am surely saying that to you. I am saying I reject the entirety of the Court of Appeal decision.
No, well, you should have
Entirely.
appealed. You should have appealed against it. That is how you know the court system works. If the Court of Appeal says something that you think is inaccurate, is wrong, is false, you must appeal against it. You never appealed against what they said there.
Isn't this
Isn't
an appeal against the entirety of this judgment, my lord?
There is not an appeal against the entirety of the judgment, Mr. Rawlins. There is an appeal on the grounds that you have brought, and there is not an appeal otherwise than on the grounds that you have brought. As you know, Mr. Rawlins, as a seasoned practitioner, what you could have done would have been to have a ground of appeal. The learned Court of Appeal erred in law and misdirected itself in fact in holding that there was an application filed on 30th of September 2008 when in fact there was no such application.
Is there anything else that you'd like us to know, Mr. Rawlins?
In view of what has transpired, I must say, no, my lords.
Okay, in your written submissions, you did not address the question of costs. In the event that you succeed in this appeal, what costs would you be asking for? Or to put it the other way, in the event that you are unsuccessful, what do you think, do you have a figure in mind that is reasonable for costs?
My lords, my lady, in matters of this nature, in Barbados, usually there is no order for cost. And that is my position.
Okay, one last thing I'd like to hear you on. Suppose you were unsuccessful in the appeal. How much time would you wish to have the appellant pay? Within how much time would the appellant be able to pay this money? Because currently, as I understand it, the state of play is that an order of imprisonment has been made against him if he doesn't pay the money. Is that correct? Is that correct, Mr. Rawlins?
Yes, it is correct.
So that if we dismissed the appeal, today, this evening or tomorrow morning, a process officer, properly speaking, should come to your client and arrest him on that warrant. Is that correct?
I'm not aware of that.
But I thought you said you agreed with me that an order had been made for his imprisonment.
That is correct.
And therefore, if the money is not paid before the process officer reaches his home, he would be entitled to be arrested.
If the court is of that is so minded, my position is, as I indicated, Molest, I thought that from the beginning, two parties being separated for 14 years, no court should have imposed any maintenance order in those circumstances. And that is what the injustice that I see in this whole matter. If the court is disposed not to right an injustice and to just enforce an order after 14 years separation, well, the court is so minded, there's nothing I could do about it. I cannot say, my lord, when or what. I cannot answer your lordship's question with a great respect. I wouldn't know when Mr. Sinckler is here, but all I can say is Mr. Sinckler is in his 70s, his late 70s, as I am, and that I don't know his means and what. Indeed, that goes to the root of what this is all about.
Mr. Rawlins, I think that you are being very unfair to the respondent. If the respondent files her applications in the court, and the court takes umpteen years before it deals with them, should that delay be to the prejudice of the respondent? But anyhow, we've gone past that. So you can't give us a period. No, let's not argue the case again. You can't give us a period of time that you think would be reasonable.
I leave it to your lordship.
Very well. Can we hear counsel for the appellant on this, for the respondent on two issues? Mr. Headley, is it?
Yes, sir.
I noticed that the Court of Appeal had ordered that each party should bear their own costs. That's correct?
Yes, sir.
Would you be content for that? Yes?
I'm gauging your question on the issue of cost.
Yes?
And in spite of my learned friend's expressions a few moments back, I want to take you to page 2, paragraph 3b of his notice of appeal on the issue of cost. It's quite instructive. Him having said all he said for the past 45 minutes or so, that he would now try to negate the issue of cost, having made it an issue in his notice of appeal.
I did. What are you talking? Now you mentioned.
Have you found page 2, paragraph 3b, under the heading, the relief sought?
Yes.
Paragraph 3b. This is what he's asking for. That a decision of the Court of Appeal made on the 12th of May 2016, dismissing, in essence, his appeal against the decision of Madam Justice Kentish, be dismissed with cost to the appellant in the Court of Appeal in Barbados and also in this court. Need I say anything else?
Okay, so you're saying that he had asked for costs, and I take it that you are similarly, if you was to be successful, are asking for costs.
Well, I always start from the premise of fairness. It'd be grossly unfair for him to come here with an application asking for cost, and now he's trying to run away from it.
Counsel, just for my edification, is there a practice, whether it is being observed by Mr. Rawlins in this instance or not, is there a practice that as Mr. Rawlins thought exists in Barbados, that in matters of this nature, the usual order is no cause? And it's a neutral question. I'm simply asking whether there is such a practice.
What I'd say is that I wouldn't say it's a usual practice, even though that's at the discretion of the court. I have been awarded costs in the court below in this same matter previously.
Okay.
Again, an application brought by Mr. Rawlins. I don't wish to go through the history.
That's
So
fine.
now this is the fourth appeal that Mr. Rawlins has brought, and in my view, quite frivolous.
Okay, thanks. You have answered me.
Yes.
Sorry.
Just as a matter of interest, if we were to order that these funds be paid and vary the imprisonment order somewhat, what would you consider to be a reasonable period?
My client has waited now a number of years to receive justice. If the order was to be varied, let's say for a month or so, to be paid within a month or paid within 2 months.
In your estimation, he has the means to pay those funds within a month?
Your Honor, I'll say this in terms of just touching very briefly on the history of the case. And I think, in the words of Madam Justice Tensis, she had made certain observations. And I think the position of the appellant from the very beginning, and guided by his counsel, and that's documented in the Court of Appeal judgment, was not to pay this woman.
Yeah.
And that's the instruction he received. Now, just to touch back very, very quickly, at the time the order was made, the judge had carried out inquiry as to his means. I'm very much aware that he receives $457.94 weekly. That's what his pension is. At the time of making this order, just before, he'd received $58,000 in gratuity. So I'm very much aware that he was receiving a pension of, let's say, some $2,000 a month. That's as far as I know. I can't speak of, obviously, the gratuity. That was a number of years back. But those figures are in my submissions.
If we were to find in your client's favor, would you accept basic costs? What's the basic cost?
I think like $40,000.
24.
Do you have a figure for costs that you have in mind?
In this court.
I was interesting, Your Honor, to hear the figures that you were just mentioning.
What's the basic cost on the registrar?
24.
No?
Okay.
Okay. The court will rise for a short bit, and then we will come back and let you know what our position is.
All right.
Yes, gentlemen, the court has come to a conclusion and which we will give now. And we don't need to hear respondent any further. The appeal is dismissed. Costs for the respondent to be taxed if not agreed. And there will be a variation of the order which was given on the 28th of March 2014 by Justice Kentish, that unless the appellant, husband, pays to the respondent wife the sum of $7,600 and such interest as may be applicable on or before the 16th of April 2020, he shall be committed to Her Majesty's Prison Dodds for a period of 10 days. The court is of the opinion that this procedure has taken too long already and so should be brought to an end. So this is the decision of the court. Reasons will be given at a later stage.
All right.